Tonight, in our sixth lecture on the series, we are concerned with the federal government and the states, or integration by law. Our speaker is a member of our in our sixth lecture on the series, we are concerned with the federal government and the states, or integration by law. Our speaker is a member of our law school, Professor Arvo VanAlstyne. Professor VanAlstyne is a member of the California Bar and Bar of the United States Supreme Court. He's a former research attorney, California District Court of Appeal, former Deputy County Counsel, Los Angeles County, former instructor at Loyola Law School, and professor of law at UCLA since 1953, specializing in fields of public law and civic procedure. Professor VanAlstyne participated as visiting professor of law at Salzburg Seminar in American Studies at Salzburg, Austria in the summer of 1962. He's a consultant, California Law Revision Commission, 1957 to date. He is the author of several books and numerous articles in the field of constitutional law, civil procedure, and local government law. He was the recipient of a Ford Foundation Law Faculty Fellowship in 1959-60. It's this grant to finance a detailed study of constitutional litigation. His topic, as I said before, is the federal government and the states, integration by law. Ladies and gentlemen, Professor VanAlstyne.
Dean Galino, ladies and gentlemen, the issues that we have under consideration tonight are fundamental to many aspects of our society and go far beyond the problems of racial discrimination and integration. They involve nothing less than the basic problem of making the rule of law a reality in a free society. Recently, Attorney General Robert Kennedy, appearing before a congressional committee which had under consideration the administration's civil rights legislation, made a statement something like this. For nearly a century, he said, we have had as one of the legal truisms of the American constitutional order the idea that all men are equal under the law. There's only one difficulty with this truism, and that is that it simply has not been true. I believe that in the context of recent events, particularly the events that have gone under the general label of the Negro Revolution, most of us have become sufficiently sophisticated to realize the fallacy in the expression which we often hear from political platforms, that this is a government of laws and not of men. I believe that today we realize that this is a government of laws, but it is a government of laws conceived, established, and administered by men. And the central problem, I suggest, in trying to work out a tolerable solution to the racial discrimination issue in America is that of redefining some of our basic principles. Certainly when the framers of the 14th Amendment, together with its companions, the 13th and 15th Amendments, wrote those words which today are central to much of the legal discussion in this area, equal protection of the laws. They had, in all likelihood, very little comprehension of the tremendous social, economic changes that would bring us to this point in society where we are today, in which equal protection of the laws must mean something quite different from what it may have meant in those days. We find also involved in the integration problem as legal issues basic problems of freedom of assembly and association, problems of freedom of speech, problems of right to vote. Freedom of association because the effectiveness of the drive of minority groups to achieve legal equality has, by reason of force of circumstances, been required to be largely through organizations. And so we have a number of civil rights organizations actively on the frontiers trying to achieve equality under the law. Their right of freedom of association has been challenged by legal mechanisms. We have even today a very bitter, long drawn-out battle which has been waged for several years in the state of Alabama between the National Association for Advancement of Colored People and the state of Alabama. Not so long ago, several years ago, as a matter of fact, a state court judge in Alabama issued a contempt order holding the NAACP guilty of contempt for refusal to publicly disclose its membership lists. Although it was perfectly clear, the United States Supreme Court later found it perfectly clear that disclosure of these membership lists would bring about reprisals, economic sanctions, intimidation, perhaps even violence and bloodshed directed to the members of that association, and which would, in all practical effect, destroy their right of freedom of association. The Supreme Court reversed this conviction for contempt, but proceedings against the NAACP in an attempt to drive them out of the state of Alabama have continued unabated. And more recently, another state court order has been entered outlawing this organization throughout the entire state. This matter is still in litigation. So we see how basic fundamental civil rights of freedom of association may be involved, and freedom of speech. Many of the demonstrations in behalf of racial equality seeking to break down discriminatory practices have involved exercises of one's freedom of speech. And the Supreme Court has, to its credit, relied upon the First Amendment in some of these cases, reversing convictions of demonstrators where they are simply exercising their right to express themselves freely and peaceably on matters of public interest. The right of citizens of the United States to vote, guaranteed by the 15th Amendment against abridgment on the ground of race or color, certainly is central to many of the issues we're discussing tonight. My point, of course, by way of introduction, is that constitutional principles, particularly, are now in the process of being redefined by the American people in the context of current conditions. Our Constitution is a living document, not one in which law is based upon conceptions of men long since dead, but instead based upon conceptions often framed in very broad and general language we might even call inspired generalities, inspired ambiguities, that must be redefined by every generation to meet the needs of its own time. As Justice Holmes cogently pointed out, the life of law is not logic, but experience, and we must redefine what the Constitution means in the light of our own experience. Now, until the present day, between the years 1875 and 1957, the principal leadership in the field of seeking to redefine what was meant by these constitutional generalities in the field of racial relations has been assumed by the federal judiciary, to some extent by state courts and state legislatures, but by and large, I think, a most remarkable role has been performed in this task by the United States Supreme Court and federal courts following suit. The decision of Plessy against Ferguson in 1896, which affirmed the constitutionality of a state statute requiring separated racial facilities in intra-state transportation, was, I think, looking at the entire flow of decisions and the entire historical pattern, something of an anachronism, and surely it was an anachronism long before the school segregation cases of 1954. Many people who should be better informed believe that those school segregation cases of 1954, and there were two opinions, but actually a total of 5 different cases involved, that those cases came as something of a legal bombshell, something totally unexpected, a tremendous change in the law, a change which has been rather severely criticized as being based upon sociological principles and not upon law, a change which has been heralded as, in many ways, reversing almost a half a century of law that preceded the decisions. This, I would suggest, is not only a gross oversimplification, but certainly in many ways most misleading and inaccurate. Judicial leadership started long before 1954. The doctrine that states may establish separate but equal facilities for the different races had been challenged many, many times, and by and large, it had been rejected long before 1954. In connection with jury service, for example, both grand juries and trial juries, it would be possible to have developed some kind of philosophy that might, consistently with the equal facilities idea, have tended to establish some forms of discriminatory or racially separated juries. But at least by 1880, this had long since been declared unconstitutional. Racial zoning, that is, state laws that attempted to establish ghetto-like areas reserved for the races, were outlawed at least as early as 1917 by the United States Supreme Court. And yet, these laws could easily be supported under a philosophy of separate but equal, because one area would be reserved for colored people and one area for white people. And the white people would be under the same disability to purchase and occupy property in the colored area as the colored people in the white area, and so it would be separate but equal. And yet that was long since outlawed, at least as early as 1917. Discrimination in interstate transportation was declared invalid as early as 1914, and in a series of cases since that time, the general principle had been reinforced and redeclared by the Supreme Court long before 1954. In the area of graduate and professional education, many people have forgotten that the first and leading case actually in this area, holding that states cannot constitutionally establish unequal facilities in the area of graduate and professional education, came in 1938 in a case involving legal education in Missouri. And gradually, over a period of years, in a series of cases, culminating again a number of years before the school cases of '54, the court had established the principle that graduate and professional education cannot be equal if it remains segregated. With respect to land covenants, in which private persons by agreement attempted to establish racially segregated housing areas, and subdivisions, property developments. The Supreme Court had denied that states could enforce these agreements as early as 1948, which is some time before the school cases. In connection with primary elections, where political parties attempted to set up all-white primary elections, ostensibly leaving it to colored people to establish their own forms of primary elections to select their candidates to run for public office. The courts had also stepped in as early as 1944 to set this aside. Looking at the entire pattern, I think it can well be said that continuation of segregated facilities in public institutions such as schools and other institutions was a legal anachronism long before the court acted. The surprising thing, perhaps, is that leadership in this area had to be taken by the judiciary and not by the executive or by the legislative branch. Later decisions following the school cases, which attempted to declare, which did declare, the unconstitutionality of racial segregation in such things as swimming pools and public beaches, golf courses, parks, libraries, museums, courtrooms, local and interstate transportation, and other public facilities, have had a significant educational effect, but as we look around the country, particularly in places in the Deep South, we find their educational effect has perhaps been submerged by the lack of perceptible practical impact. These decisions, I think, have served as a focal point for marshaling public opinion, as a criterion for determinations of public morality, as a goad to the conscience of the American people, and thus perhaps as a foundation for continued evolution of our legal doctrine. But I think that as we look at the situation today, nearly 10 years after the school segregation cases, we cannot be proud of the results that have been achieved in the name of the rule of law. Perhaps we can identify certain limitations in our legal institutions which may be properly accountable for this lack of a more rapid development. The limitations upon judicial review, upon the use of courts as an enforcing instrumentality in the development of solutions to problems of racial discrimination, I think stem from a number of sources. In the first place, in the absence of affirmative enabling acts vesting the courts with special jurisdiction to implement affirmative policies already declared by the legislature, the courts are relatively powerless to do anything except in an essentially negative way. The courts, when called upon to enforce a racially discriminatory policy, may have the power in some situations to declare the state policy, state law, state custom even, to be unconstitutional and unenforceable by the courts, by executive officials, and by police action. But this, you see, is essentially a negative role, the courts merely saying no. The courts do not have the power to take the affirmative, to formulate and to establish affirmative policies and provide effective remedies for those policies. Secondly, the decisions of the courts are to a very large extent restricted to the parties before the court. Now, it is true that the decisions of the Supreme Court, such as the school segregation decision, are entitled to great respect and, in fact, under the principle of stare decisis, are required to be followed by state court judges and federal court judges. But the difficulties with the rule of stare decisis, so-called, the rule that courts must follow prior decisions that are controlling, is that in many situations, the later cases can be distinguished from the earlier ones. It can be said, well, the facts have changed, circumstances are different, and therefore the earlier decision is not strictly binding upon us. With respect to the parties before the court, there are certain procedures which sometimes can be invoked to broaden the scope of effectiveness, one of these being the use of what is known as a class action, in which certain limited numbers of individuals will sue in behalf of a broad class of individuals. But even here, the effect of a court decision often is somewhat restricted. A court decision seldom can reach beyond the boundaries of the state in its effectiveness. As a result of these limitations, we find it necessary, and we find a pattern now developing to use this role, find it necessary to have repeated actions in the courts brought in many, many localities to reestablish over and over and over again basic principles which ought to have been long since regarded as beyond the scope of relitigation. Courts, in other words, are a somewhat inefficient tool for implementing basic social policy. Thirdly, a limitation that is not widely understood outside of legal circles, I think, stems from the fact that courts are established primarily to resolve controversies between individual litigants, controversies based upon narrowly drawn pleadings, controversies in which the issues are carefully framed and the evidence which is adducible with respect to those issues carefully screened through rules of evidence that are designed primarily for the resolution of private disputes in relatively narrow confines. Most of the issues involved in litigation arising out of racial discrimination problems, however, are issues that go far beyond the usual scope of lawsuits. And I think in many ways, legal procedures, therefore, do not lend themselves well to the reception of the kinds of evidence and the evaluation of the kinds of public policy considerations that really are central to the resolution of these problems. For example, suppose you do have a state which has a fair employment bill on the books. And the problem now is, how are we going to enforce the rights of fair employment? The right of the individual not to be denied a job or not to be discharged from a job on the ground of race or color or some other irrational consideration. The difficulty here, I think, is pointed up sharply if you just imagine the problem that a litigant might have, or a public official might have if he were the enforcing officer, trying to prove that an individual employer actually made the decision not to employ a given individual on the ground of race or color, when that individual himself, perhaps rationalizing, perhaps in good faith, is willing to testify that it was not on the ground of race or color, but on other grounds, such as lack of adequate training, lack of adequate experience. His personality was not the kind that I thought would be useful in meeting with members of the public, and other types of considerations which are independent of race or color. These kinds of problems of proof, of trying to get to the heart of the issue of human relationships, are the kinds of issues on which judicial procedures often are almost hopelessly inefficient to resolve. They're the kinds of problems that must be worked out by means of persuasion, by means of discussion and trying to get people simply to change their basic attitude toward their responsibilities in our society. Fourth limitation that might be pointed out with regard to the use of law as a means of resolving these problems relate to various technical aspects of judicial review that limit the freedom with which the courts may undertake to assert any form of initiative in these matters. For example, one problem that has become quite significant in recent months, running through the cases, is the problem of the extent to which the federal government, acting through the Attorney General, may bring actions in the federal courts on behalf of private persons to enforce the principle of equality under the law. Generally speaking, in the past, it has usually been held that the person who is suing must be personally, directly, adversely affected by the unconstitutional or allegedly unconstitutional action. And yet, to leave the resources of litigation to private individuals who may not have the funds, who may not have the initiative, who may not simply know of the availability of legal remedies for their wrongs, is a rather inefficient way to handle these problems. And so the Civil Rights Division of the Department of Justice has begun a campaign to institute, in the name of the United States, actions directed at public officials and in some cases against private individuals, seeking to enjoin them from concerted action designed to deprive Negroes of their constitutional rights. And in a number of these cases, the United States federal courts have held that the federal government has no standing to sue and have dismissed the actions on the ground that the United States has no power to commence such lawsuits in the federal courts. We do have some statutes that expressly give the federal government authority to do this. The 1957 Civil Rights Act, for example, said the Attorney General could bring these actions to enforce equality of voting rights. But in other areas, we generally don't have any such statutes. And the exact extent to which the federal government may commence these actions on behalf of private citizens is still in a state of flux. We're not quite sure of the results, but it does create serious difficulties in seeking to make these rights meaningful through the processes of litigation. Another issue that is of a technical nature that eliminates the use of effective court action in many cases is a continuing uncertainty as to what is meant by the word state action, or the concept of state action, which is central to the operation of the 14th Amendment. That amendment only forbids states to deprive persons of their rights of equal protection under the law. Not private persons, states only. The question is, when is the state acting? Now, it is perfectly clear that when the state is acting through its executive, legislative, or judicial officers, it is acting. But there are limitations even on that concept. When, for example, a state officer is simply enforcing a totally non-discriminatory state statute on criminal trespass, for example, one which makes it a crime to remain on the property of a private person after being ordered to leave, is this the kind of state action that the 14th Amendment was designed to forbid? Well, the Supreme Court has said it is if there is some other involvement of the state, such as a state statute or local ordinance that requires racial separation in restaurants and public facilities, which the criminal trespass proceedings are invoked to try to enforce. The Supreme Court has said that it is enough if it is coupled with something else, such as a declaration of official police policy that they will use the criminal trespass statutes of the state for the purpose of enforcing a local custom of racial segregation in public facilities. But the question is still open, you see. Suppose we don't have any local statute or ordinance. Suppose we have no official declaration of public policy to enforce a custom of discrimination. Is then the enforcement by non-discriminatory means, such as criminal trespass statutes, a violation of the 14th Amendment? This is the kind of problem that's still open, creates enormous difficulties for litigants, enormous hurdles that must be overcome, and therefore, before one can effectively even seek to prosecute a remedy, he may have to invest an enormous amount of money and time and energy in trying to litigate these open questions. I would suggest that there are others that are of a technical or practical nature that can be classified as limitations on the effectiveness of judicial review. One of them, which has been rather increasingly apparent in the cases in recent months, arises from a conflict between two constitutional rights. On the one hand, the constitutional right to legal equality. On the other, the constitutional right to a jury trial. And so when actions are brought seeking to enforce the constitutional right to equality by, for example, a civil action under the Federal Civil Rights Bill, the defendant is entitled to a trial by jury. And a trial by jury in some southern communities in behalf of a Negro plaintiff seeking to obtain damages because of the unconstitutional action of public officials may be totally fruitless, because juries simply will not render judgments for damages against the defendants. And yet here you see you have on the one hand the constitutional right to jury trial in conflict, in effect, with the underlying policy of equal protection. Well, in addition to these, what we might call legal limitations on the use of the power of courts to act in this area, there are certain practical limitations that certainly are entirely meaningful, and in many ways much more meaningful than the judicial limitations. One that we've only just begun to grapple with in our society is the continuing malapportionment of state legislatures. The Supreme Court, in the very great case of Baker against Carr, recently held that the federal courts do have the jurisdiction to consider actions brought to enjoin continuing malapportionment. Now, there are cases presently pending in the United States Supreme Court in which, hopefully, the court may be able to lay down some guidelines to determine standards for proper and fair apportionment of state legislatures, to make meaningful the constitutional principle that every voter is entitled to have his vote counted equally with every other voter, or at least substantially equally. This principle of malapportionment is certainly a very significant one in the area of racial relations, in the Deep South particularly. By and large, over the past several decades, there seems to have been a tendency on the part of racial minorities to congregate in cities. At least those racial groups and members of racial groups which are most vocal, which tend to be better educated, which tend to be the best organized, and which therefore are in a position to take the most meaningful collective action designed to try to eliminate racial discriminations, seem to be collecting in our cities, in the urban areas. And yet it's these very same urban areas which traditionally have been partially disenfranchised by the continuation and the solidification of malapportionment schemes drawn up largely by rural-dominated legislatures. Well, as time goes on and malapportionment begins to disappear from the political scene, of course the impact will be felt by the urban white voter as well as the urban colored voter. But at least this will tend to make more meaningful the organized vote of the city dweller, and perhaps will have a very definite impact upon the amelioration of racial conflicts. We find already in Georgia, I believe it is, that one of the state legislators from Atlanta is now a Negro, as a result in part of court actions which have declared the Georgia County Unit voting scheme to be unconstitutional. Another practical problem, I think, stems from the fact that in many southern communities there seems to have been almost a concerted effort on the part of public officials to defy law, to actually resist intentionally, knowingly, the law of the land. We've seen this in the most prominent public officials, the governors of several of the so-called sovereign states of the Union, who have publicly said that they will defy the United States government. And they've called upon all the citizens of their states to join them in this defiance. We found state legislators passing resolutions seeking to impeach the members of the United States Supreme Court, resolutions of nullification and interposition seeking to declare the decisions of the Supreme Court null, void, and ineffective within their state boundaries. These actions, I suggest, scarcely can be labeled as having been taken in good faith. the law of the land as declared by the United States Supreme Court has long since been brought within the concept of supremacy, which is embodied in the Supremacy Clause of the Constitution. And the federal law is supreme over state law to the contrary. The Supreme Court, in the case of Cooper against Aaron, deliberately took the occasion, in connection with the Arkansas Little Rock school controversy, to write an opinion in which all 9 justices joined as authors of the opinion, an almost unprecedented move, which they declared resoundingly that all state courts, state executive and legislative officials are bound by the law and by the Constitution of the United States as construed by the Supreme Court. But despite this principle, we still find this continuing defiance, this continuing refusal to abide by the rule of law in certain segments of official society, in the Deep South particularly. In some rural areas, for example, there's a great deal of evidence that is accumulated. Much of it is collected and published in the reports of the United States Commission on Civil Rights, showing all kinds of intimidation, duress, coercion, economic sanctions directed against racial minority groups, individuals thereof, who simply are trying to assert their constitutional rights. We're perhaps familiar with the experience in Haywood County, Tennessee, where Negroes who were in many cases tenant farmers, not in good economic condition, were the subjects of very severe, almost savagely brutal and oppressive economic sanctions, almost taken to the very point of starvation itself by the dominant landowning and economic interests in that county, in an effort to restrain and coerce these individuals into not even registering and not trying to exercise their franchise. The Attorney General of the United States brought an action to enjoin this sort of thing. The action was finally settled by agreement between the defendants that they would no longer indulge in these kinds of tactics. But it tends to illustrate what happens when public officials call upon citizens generally to disregard the rule of law and to flout it, to fight it, to resist it. When this takes place, the principle of rule of law tends to break down in operation. At least it's very difficult to cope with this kind of thing in the confines of litigation in the usual sense. Then there's another tendency of a practical nature which is, I think, becoming quite noticeable in many parts of the nation, both north and south, in which racial segregation, both actual and intentional, and de facto segregation, which is often a characteristic of northern, even western civilization and society, where these kinds of problems are being met by not a good faith effort to resolve them in a wholehearted way, but instead by the pernicious doctrine of tokenism. The idea seems to have developed that we can comply with the principle laid down in the school segregation cases, for example, if we will simply allow 1 or 2 well-selected colored students to enter the white schools. And this then, token integration, if you will, becomes the final solution in the minds of many people. And yet, in a very real and meaningful way, this concept of tokenism is a far more pernicious doctrine than is the concept of total separation of the races. Because tokenism has the superficial aspect and appearance of compliance with the law, thereby salving the conscience of those who seek in this way to continue to deny first-class citizenship rights to our minorities. And yet, at the same time, it accomplishes the basic discriminatory result which is to be achieved by those who use this method. Tokenism is a very difficult doctrine to fight in the courts because you have the basic problem of motives, of human intentions, of the hidden thoughts in the minds and hearts of the individual public officials who are involved and the private citizens that support this approach to the problem. Tokenism becomes an exceedingly difficult, enormously expensive type of tactic to fight effectively through the processes of our legal institutions. One of the reasons why so many of these tactics, delaying tactics, subterfuges, ingenuous as well as ingenious devices to try to evade the principle of equal justice under law, are so difficult to cope with in the course of litigation and through legal institutions, is that our legal institutions simply are not manned and simply are not supplied with adequate resources to meet the need. For example, I think it is fairly clear today, and this, I might say as an aside, is one of the most crucial problems in the whole issue of administration of justice. One of our critical needs today is to solve the problem that can be characterized by the saying that justice is only for those that can afford it. Justice, unfortunately, is expensive. Oh yes, we've made some strides in trying to provide legal counsel for those who are unable to afford it, but this is particularly in the area of criminal defense work. And even here we've got a long, long way to go before we achieve the ideal of having equal representation for even the criminal defendant. But in the kind of civil litigation, which is so often the context in which racial problems arise, we find the need for the development of large economic resources, financial resources, before litigation can successfully be brought. This then forces the individuals involved to organize, to try to collect funds on a wide-scale basis, and then to utilize the limited resources that are available in selected areas. And one simply can't cover the entire front all at once. There just isn't enough money available. The NAACP has been notable in the development of financial resources and legal talent to bring actions, but it has always had to very carefully select its cases, very carefully mount organized campaigns directed at specific and narrow areas in which racial barriers should be broken down. As a result, there must be thousands and thousands of cases of racial intolerance and injustice which simply goes unremedied through the ordinary courses of legal process simply because the individuals involved don't have the funds with which to exploit and carry out to a successful conclusion the remedies available to them under the law. One of the most serious defects in this, and I would suggest a defect as to which the bar in many of the southern states as well as in parts of the north and west certainly has been grossly remiss, is in the fact that there are very few capable attorneys, matter of fact, very few attorneys at all, who are willing to handle civil rights litigation. One very prominent white attorney in the South who was willing to handle these kinds of cases apparently has been hounded out of the South and cannot effectively continue to practice there because of the various kinds of indirect and direct sanctions brought to bear against him. One recent report indicates that there is only one colored attorney in the entire Deep South who consistently, as a practice, handles civil rights cases. And yet there are literally thousands of cases that need to be handled. The organized bar of the southern states, I think, has simply not measured up to the professional responsibilities which it should recognize of providing adequate legal resources in the way of counsel and attorneys to handle these matters. And then, of course, there's the harassment of those organizations that do seem to be successful in accumulating funds like the NAACP. I referred to the battle it's had with the state of Alabama. Well, in this context, certainly ordinary legal remedies don't seem to be too effective. And then finally, in terms of practical limitations on the use of law to bring about a solution to the racial segregation problems and racial discrimination problems, I think we have to realize that many of these problems are simply beyond the purview of law as an instrumentality in society. Many of the problems stem not from essentially legal sources, but from essentially sociological and economic sources. I think that in many ways, de facto segregation can probably be attributed in places like California, where at least for legal purposes such segregation need not exist. Our laws certainly seem to be reasonably adequate to break down the barriers of residential segregation. But in these places, it seems to stem largely from economic factors. The inequality of job opportunities, the inequality that has so permeated our society that we find many labor unions, for example, following grossly discriminatory policies with respect to membership. Many employers who seem to stereotype minority groups and feel that they're incapable of performing other than rather menial and low-paying tasks in industry. These kinds of patterns of economic and sociological development certainly keep down, in a very meaningful way, the economic incentives, the educational incentives of our minorities, and therefore have a pernicious influence in terms of the ready mobility of the minority to spread and develop into society and take its place in all segments of society, along with other racial components of the society. So that to the extent that these problems don't have a legal basis and cannot be effectively met by legal mechanisms, we find that the institutions of law tend to break down. It is possible, of course, that with more sophisticated approaches, with the development of more carefully defined techniques, legal institutions might be brought to bear on some of these problems. We find already, of course, certain indications of newly developing techniques being utilized by the federal government. The President, for example, in his order of November 1962, banning racial segregation in publicly supported housing projects to be commenced in the future. This gives one indication. The federal government has vast resources at its disposal in the terms of distribution and handing out of subventions of public funds for various purposes, which can be utilized as sanctions, which can be utilized as rewards if we would but give consideration to their use for that purpose, and tend to break down, or at least to deal somewhat effectively with the economic and sociological problems that are at stake here. The federal government, which is, I suppose, our largest single employer, has begun various programs to try to implement non-discriminatory hiring policies in federal employment. The evidence, however, suggests that even the rather strenuous efforts that have gone forward, even the public pronouncements of the President himself and the heads of various departments, have had an enormous amount of difficulty in trickling down to the local offices in which actual employment practices are carried out. Recent evidence indicates in Mississippi, for example, that many public offices there have practically no colored employees except in a rather menial or custodial capacity. Very few in supervisory capacity, very few in any employment or occupational categories that require special training and skills. And yet the evidence indicates there are a substantial number of Negro citizens who are capable of fulfilling better jobs. So there are practical difficulties even within the structure of government itself in making adopted policy by the highest sources in the administration actually effective at the local level. In 1961, the Interstate Commerce Commission adopted broad and pervasive orders restricting the use of interstate transportation facilities and terminal facilities which were operated on a racially discriminatory basis. And yet latest information indicates that in many parts of the country, colored passengers still are subjected to discriminatory practices in the very facilities which are the subject of these orders. Their enforcement is the difficult problem. In some ways, the operations of the Federal Civil Rights Commission have perhaps been the most effective in bringing to bear the opinion of the public with regard to the problems we're discussing. The Civil Rights Commission established by the '57 legislation was designed primarily as a fact-finding body, and the massive information that it has accumulated has certainly underscored the realities of the problem in vivid detail. But again, we haven't yet begun to take serious heed of the needs for sophisticated, enlightened, well-thought-out legislative and executive approaches to the solutions of these problems. Most of the action that has been taken so far has been of a rather ad hoc nature, sporadic, designed to perhaps meet the needs of a specific narrow area, but very little in the way of a broad gauge program. The presently pending civil rights legislation and its very doubtful prospects of passage in the present Congress, I think, underscore the difficulties of attempting any kind of broad gauge program of this kind. For practical reasons, it is almost impossible to get legislation of an effective nature through our present National Congress. I think another aspect of this problem of trying to seek a broad gauge approach stems from the fact that there's really been very little constructive attention given to sociological factors in the enforcement of law. The average way in which civil rights legislation is written is to simply take a basic policy, such as the federal civil rights legislation, and say, now in public accommodations that have any relationship to interstate commerce, we're not going to have any more discrimination on race or color grounds. And then how do we enforce it? Well, one way to do it is say, well, let's let the courts enforce it by injunctions. We'll allow the government to bring actions to enjoin discrimination. How many thousands of restaurants, motels, and hotels might have to be made defendants in individual lawsuits in order to make that sanction effective? You see the problem? It's simply saying, let's bring thousands and thousands of lawsuits and gradually we can break down the problem. Yes, gradually. Perhaps in the next century or so we might make a real dent with respect to public facilities and public accommodations by litigation. But I think there is a point at which, there's exhaustion of litigation too, and the litigants themselves become exhausted and little is actually accomplished. Another way to write this kind of legislation is to set up the standard and then say anybody that violates this is guilty of a crime. And yet I would think that experience has long since shown that in many communities in which the general consensus of public opinion does not support the underlying policy of the law, you just can't get convictions. You just can't get convictions. Certainly the experience under the Prohibition laws was a good example. Recently in California we've had some experience in the enforcement of narcotics legislation. As soon as the narcotics penalties for violating narcotics laws become stiffer and stiffer and stiffer, pretty soon the juries become more and more reluctant to convict because the penalties are too severe. And this sociological aspect of the problem, I think, is particularly pertinent when we realize that enforcement by criminal sanctions must take place under the Constitution itself in the district in which the violation took place, and therefore before a local jury, one which is ordinarily going to be, at least in many parts of our country, completely sympathetic with the defendant and not the plaintiff who has been discriminated against. And I think what we need then is a very sophisticated sociological analysis and perhaps a great deal of hard work in the area of sociology, in the area of social psychology, to develop better ways to bring to bear a variety of sanctions which will make these fundamental policies meaningful. Rewards, for example, may be very effective. Deprivation of advantages and privileges may be very effective. I think there are a number of ways in which we need to take a more discriminating look at the way in which we try to bring about changes through the use of legal mechanisms. Well, I think that perhaps I've said more than enough as to the limitations of law and its role in bringing about a solution to these problems, but I would like to conclude by taking another tack. Although law has very definite limitations, very definite restrictions, very definite practical impediments to its effectiveness in bringing about a solution to the racial problems of our society, law has, I submit, a most significant, even though limited, role to play. I do not mean to minimize it. I do mean to point up the difficulties. But law does have a role to play. The old philosophy, I suppose, attributable largely to the sociological ideas of William Graham Sumner, that law cannot change habits and social customs and traditions. This sociological premise that really was the basis of Plessy against Ferguson in 1896, I think long since has given way to a more reasonable view of the role of law in our society. Perhaps law cannot actually change the feelings in the hearts and minds of people, but I think that law can do something. Surely, the law can influence attitudes and ideas. Certainly when a basic principle such as racial discrimination, which at its heart is a moral issue, is embodied in law, and when public officials stand firmly in behalf of the enforcement of law, the law itself has a very significant impact upon the ideas and attitudes of the public. It tends to awaken the conscience of the people, tends to get people perhaps to search their own basic presuppositions and to begin to re-examine the way in which they behave themselves, to see whether they're acting consistently with the policy of the law. This, I think, follows from the fact that most American people tend to be law-abiding. They tend to realize that the law does, to a very large extent, embody the collective conscience of the people, the collective sense of what is right and just. And therefore, law can have an influence not only in enforcing the moral code, but also in changing the moral code. And secondly, law performs a very significant function in simply preventing or enforcing or punishing those most antisocial aspects of behavior with which we're dealing. For example, we can't by law perhaps legislate out hate in our society, but we certainly can legislate out murder and punish those who commit this crime. The overt antisocial act, in other words, can be legislated against, and effectively, if public officials will effectively enforce the law. And so to this extent, law certainly performs a very valuable role. It's a reinforcing agent and gives great moral sanction to public officials who are willing to carry it out. But I think in the long run, what we need in our society to fulfill the general promise of freedom and equality, which was made to all people without regard to race or color nearly a century ago, we need more than mere reliance upon statutes and upon administrative orders and upon court decrees. What we need perhaps is a coordinated program to marshal the resources of both state and federal, legislative, executive, and judicial instrumentalities in an effort to secure responsible law enforcement in the area of civil rights at all levels of government. A coordinated program to seek to develop the public conscience as well as the individual consciousness of the American people as to the moral evil of racial discrimination. And in this way to seek to bring about a basic change in the public outlook toward minority groups. Law that does not command the public support and confidence of the people tends to demoralize the entire society. And experience suggests that law is most effective when it faithfully reflects rather than seeks to mold a community consensus. But I would conclude that nevertheless our legal institutions have a significant role to play in making the principle of equal justice under law a living reality in our society. Thank you very much.